Right, can I welcome everyone to this, the 7th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when they're switched to silent. I hope mine's off, not sure, it's a new gadget, we'll find out. Apologies have been received from Alison McInnes and David McCletchie. Item 1 is decision to take business in private. Our first item is whether to take item 5 in private. This is being proposed as a private item as it relates to consideration of an approach paper, and possible witnesses may be discussed.
You've given us an explanation of why you would want to do it in private, and I think that's helpful to us. It allows us to understand the logic behind the proposal. So it saves my question. That was exactly the question I was going to
We
make.
also have actually 2 pieces of correspondence. I don't think they're in the public domain that relate to it, and I want us to be able to use these and discuss these as well. So thank you very much.
Thanks,
Item 2, subordinate legislation. 3 negative incidents arising from the Police and Fire Reform Scotland Act 2012. The Police Service of Scotland Regulations 2013 SSI 2013-35, Police Service of Scotland Promotion Regulations 2013 SSI 2013-39, and Police Service of Scotland Special Constables Regulations 2013 SSI 2013-43. And as you'll see from your papers, the Subordinate Legislation Committee has drawn our attention to SSI 2013-35 on a number of grounds. There's an understatement, including defective drafting, and to SSI 2013-43 on 1 drafting error. On both instruments, the SLC has suggested this committee may also wish to consider the practical effect of what it describes as the unclear meaning of dependent in relation to a constable or special constable's business interests. The Scottish Government wrote to the SLC, copied to this committee yesterday, you have that letter, to confirm that it intends to prepare amending regulation to be laid as soon as possible after the SLC completes its consideration of the police and fire reform instruments. And you've got that letter, as I say, it was circulated electronically. I hope all members have it. Okay, it's the one with the funny letters on top, so you can't copy them. Right, do members have any comments in relation to those instruments? Okay, so if you're happy, you can not to make any recommendation, and we'll see what comes next. And I take it the amending regulations will also come to us. Yes. So we have the opportunity then. Thank you very much. The next item, consideration of correspondence from the Scottish Police Authority on the codicil, referred to in its earlier correspondence on the responsibility of human resources and finance. You remember that we asked the SPA for a copy of the full document exchange of correspondence that comprises the codicil. The SPA has provided a copy of correspondence from the Scottish Government. The SPA's response to that letter, both dated 17th January. Do members have any comments? At the beginning and finish at the end, possibly with a middle.
Could I leave it to other members to comment first and then be given a chance at the end?
My first brief comment is it took an awful long time to get where we are, and I don't know why. So perhaps you'd like to expand on it, some of you. John, do you want to come in?
Thank you, Convener. Yeah, a bit of a damp squib at the end of the day, and I can't understand what the reticence. I think what's terribly important is the language that's used by people on the committee and those that we're seeking to get information from. And I think we need to see more of a willingness. I note, for instance, that Mr Emery is a little disappointed the committee doesn't feel able to meet with the wider membership of the SPA board. Well, I think we are more than a little disappointed with dealings thus far, and I'm sure we'll have good relations, but it's important that the flow of information requested from this committee doesn't require the protracted business that our staff have had to undertake that this has, for what at the end of the day was a fairly modest.
Yes, and of course the position was that we were saying to the SPA board, you're no different from any other board.
Yes, indeed.
We simply don't have them in front of us as individuals presenting a case, no matter what that case is. So there's nothing different in the processes there, and they mustn't take it personally. Colin.
Thanks, Convener. I think just say a general question. We've had 2 pieces of legislation, one on police, one on fire and rescue service, which are more or less identical, and it does seem really odd that the only real problems we've had so far have come from the new proposals for the police service. And it's an interesting thing, maybe it's just anecdotal view that I'm taking. There's one set of people, the fire and rescue service, have had two senior people, one from a local authority background, one from the Fire and Rescue Service, who seem to have come across a good way of working, working away together quite well, and there's been no problems. In terms of the police, it's been someone from private business talking to a police officer, and it just seems to be that maybe it's a culture change, or there's a difficulty within the cultures that is proving difficult. I don't know, but it would be interesting to see how effective the actual arrangements leading up to the first day of action, so to speak, how easy they've been overall for both services.
I think they're not quite identical. I know we say broadly they're
Broadly identical.
Yes, because there are certain, in statute, there are certain duties and responsibilities to the SPA, in particular with relation to certain staff, and we know that. But I take your point that there may be a cultural issue here between local government liaising with police and perhaps someone from the commercial sector, without personalising, just the commercial attitude. I think it's just fair enough, liaising with the police. Graham, your moment.
Thank you. I mean, I think it's extremely regrettable that it's taken such a time to obtain the detail of this codicil as it's been described. I don't think the initial response from the chair of the police authority gave us the full colour of the relationships between the authority, the service and the government, as was later exposed within the appendices of the paper 1374, particularly the two, one from Vic Emery and the other one from Paul Johnson. I think that there seems to be reflected there. I don't think I remember reading from a civil servant a description of proposed arrangements as unbalanced, confusing, and placing the service in a unique and invidious position, which is almost an angry term from a civil servant. And then the response from Vic, which doesn't seem to me to be engaging and warm, stressing the length of their consideration and indicating that the proposals were neither modest nor insignificant. And then towards the end, talking about difficult decisions that the board face and the reservoir of patience with protected nature of resolving this kind of issue. It doesn't augur well, and I would hope that, having rehearsed these matters at Justice Committee, that the authority, the convener, the Chief Constable, the civil servants and the Cabinet Secretary will now put their minds on the business of the future and placing a police service that creates safe communities for Scotland. This seems to me to be a spat in the playground.
Well, I think I did use some kind of metaphor about football in the playground being taken away at some point by one party or the other. I think you're quite right, and I don't think the committee foresaw this kind of public. I'm sure these matters go on. Oh, goodness me, there's that word, matters. I'm sure these instances happen in other circumstances, but not usually played out in public, which is the regrettable instance about this. Obviously, I think there had to be some adjustment between these parties, but I think the regrettable thing was it was played out in the press, and once you do that, you've dug yourself into positions that it's sometimes difficult to dig yourself out of. But that said, I'm delighted we've got this far, and I have to say that I think the subcommittee, I'm taking Roddy next, the subcommittee is moving its way through the various technicalities of this Parliament, and that should, again, give focus to this partnership, let's call it, between the parties. Roddy?
Just briefly for the record, I must admit, I found Mr Emery's correspondence somewhat intemperate, and I found his final paragraph, certainly in terms of its final sentence, somewhat ironic.
Yes, I just read it again. Yes, I think let's leave it at that. We don't want to... It seems like there's some healing process going on. Let's not open up wounds again. But I'm glad we've got this far, and I thank the committee for pursuing it, and we will continue to pursue what's the most important thing is to have a good single police service in Scotland. I want to move on now to item 4 and allow the witnesses to move into place, please. Okay. Right, I hope you've been asked lots of questions on this. Yep. Right. Thank you very much for coming before us, and this is item 4, inquiry into the effectiveness of the provision of the Title Conditions Scotland Act 2003. It's our first evidence session into the effectiveness of the provisions of that Act. We'll hear from 2 panels of witnesses today. Members should have received the written submissions with their papers. In addition, a late submission was received from Your Place Property Management, who will be hearing from in the second panel. It was circulated to members and a hard copy has been placed on your desk, and I apologise to members for late papers. You have plenty of papers, and I know late papers are not helpful. I'm not blaming anybody for sending them in late, but it is helpful. We can have papers ASAP. Can I welcome our first panel of witnesses to the meeting? I've got Alec Middleton, Chief Executive Officer of Greenbelt Holdings Limited, Wendy Quinn, Solicitor with Greenbelt Group Limited, and Kevin Wilkinson, Director of Ethical Maintenance. Good morning. Thank you very much for coming, and I move straight to questions from members, please. Roddy, then Jenny.
Good morning. Could I just ask the representatives of Greenbelt for a piece of clarification more than anything else? You talk in your submission about the new initiatives under the Property Factors Scotland 2011 Act, but you also describe yourself as not being a property factor. I know that in the case of Greenbelt Energy Limited, they have taken the view that they're not required to register under the Act, a matter which I have referred to the Scottish Government. Can you clarify whether any companies in the Greenbelt Group have registered under the Property Factors Scotland 2011 Act?
2 companies, Green Home Property Limited, which is a property factor in the sense that they look after tenements and common parts, and Greenbelt Group Limited, which looks after open spaces under a single ownership model, which is no doubt what we will discuss today, and has about 20,000 households in Scotland, part of probably about 40-odd thousand in the UK.
So those 2 companies have registered under the Act. Okay,
The company that you refer to, Greenbelt Energy, is simply a land holding company, as in any party who owns land.
Well,
we own land.
I take a different view about that, but I have referred it to the Scottish Government, who I understand are in contact with the company about that, but we'll leave that there for the moment.
I think it's important to clarify, because I've been in front of a Justice Committee before, and we clarified exactly what a property factor or property factors, the Property Factors Act would cover, and that is companies which charge for a service. So Greenbelt Group charges for a service, Green Home Property Management charges for a service. Greenbelt Energy does not. It's simply a landowner.
Yeah, well, to leave that one there for the moment. But the rest of your submission, if I might say so, there displays a certain kind of irritation, if I might put it that way, the idea that some of these matters might be being referred for further consideration either by government or parliament. Was there anything you might want to add or clarify that in terms of your submission?
No, I think possibly. I mean, that's an interesting first question, if you don't mind me asking. You know, as a company, we're a Scottish company. Many people, the employers, are from Scotland. We operate throughout the UK, and we're proud of the fact that we say we're a Scottish company operating throughout the UK. In terms of day-to-day, we get on with business. I don't believe that there is an irritation behind our I think what might come through is the fact that we've already been here before. We've also made various comments. We've also submitted an extensive consultation document 2 years ago, and we've yet to see that published. And, you know, if you call it irritation, fair enough, but as far as we're concerned, we just basically respond. We come up to see you. We are honest, we're open. We try and give as many facts as possible. I don't think it's irritating. I think it's possibly a wee bit of frustration if you're to be honest here and say, well, you know, why haven't we dealt with the issue before? So we're quite happy. We're quite open. We're quite upfront about coming here and to speak to you.
And one further small question before I let others in, I think. Just in terms of the appointment and dismissal of managers, you refer in your submission to your consumer choice and the various terms on that. How well publicised are you making that to kind of individuals in many of these developments who are very unhappy with the services of your group?
Maybe I could just answer that one.
Yeah.
Consumer choice option is published on our website, Greenbelt Group website, and under the new Property Factors Act now we're issuing written statements of services to all our residents on each occasion when they receive a bill. So the consumer choice option accompanies the written statement of services, so every resident will also receive a hard copy of that.
Good, thank you for that. Okay, I'll let others in.
Jenny.
Good morning. Thank you for coming to the committee this morning. I mean, I just wanted to maybe ask all three witnesses if you can briefly take us through your main points on this. I mean, we've got your written evidence in front of us, but I'm sure my colleagues will agree there's very few of us on the committee are experts in property law and the more technical details of title conditions and enforcement of burdens. But certainly my interest in this is that I've heard from people in law and certainly through our casework that Section 53 of the Title Conditions Scotland Act may not be operating as well as perhaps it was originally intended or has unforeseen consequences. And I would be grateful if each of you could perhaps briefly share with us this morning your opinions on that in the most accessible way possible for us non-experts.
I think that's very helpful, and I think that's a very useful question to ask us. Perhaps, I mean, we've known each other for a long time, but perhaps maybe I could suggest that I perhaps give effectively a commercial angle. Obviously, Kevin can give a commercial
Sorry,
angle
but
first.
who have you known for a long time?
Sorry?
Who have you known for a long time? Oh, the witnesses. I just wanted to not imperil Ms Mara's independence here.
No,
we have
not
known
at all.
each other for a long
I've
time.
never seen the man before.
Excellent. You get that in the record.
Okay. That's great. I love
Sorry
a bit,
to
I love
throw
a
you
bit
there,
of
but
humour
I
as well, actually, so it's
Just
good.
came out strange, yes. Please.
Well,
yes.
Kevin's obviously, I'd imagine that Kevin would give a commercial angle as well. And I think, importantly today, brought along Wendy. Wendy's been involved in conveyancing for a career, if you like, and a long time with Greenbelt. She's very au fait with the legislation we're talking about just now, and I think it's very useful to have Wendy along today. So I think from a legislative point of view, she'll be very helpful today. And as I say, she'll probably present it in a slightly layman terms so that we can all grasp it, because even we have to try and grasp it as well.
Good, thank you.
In terms of actually Greenbelt Group and Green Home, I'll just say Greenbelt just now. I did prepare a statement which is maybe about a minute and a half, and I think probably if we go through it, I think it picks up the main points. And think, first of all, thank you for the opportunity to provide evidence to the committee. Greenbelt has provided oral evidence previously to government committees on property management, and also a number of submissions providing extensive evidence. The latest being the consultation to the land management company submitted 2011, which I refer to, and yet to be published. We've also made representations to other organisations, for example, Scottish Government, individually MSPs, MPs, Office of Fair Trading, Consumer Focus Scotland, Trading Standards, Information Commissioner, Ipsos Mori, Sheriff Courts. We've made representations throughout. Our submission to this inquiry reiterates much of what we presented in 2011 submission, providing our current views and the questions raised by the committee at the time. But we base it on facts. Greenbelt's experience over some years as a provider of land management services to 20,000 households in Scotland. And we also operate in England and Northern Ireland and in Wales. I believe that we are actually best placed to provide the committee with the necessary evidence to provide to form a balanced view in relation to land management companies, and we're quite happy to do that. In relation to the two primary questions, first of which is, do householders have effective recourse for dissatisfaction of services? Second question, is there a current mechanism to remove a land management company? I think commercially that's really the primary questions. The answer, in our opinion, in our experience, the answer to each is yes, through existing legislation. And this has been clearly reported to the committee in our submission. Perhaps Wendy will pick up on that in a minute or two. One matter which is not clear or addressed by the questions, though, is the question of ownership of the open land and the responsibilities of land ownership. If the provider of that maintenance is removed, having an alternative and willing landowner which is prepared to undertake the ownership, the maintenance, the responsibilities, the liabilities, ensure safety on the land, ensure the related property values are maintained at householder expectations, must be addressed comprehensively, responsibly. It's important also, and I'll pick up a point just now, it's important also to clarify Greenbelt's place in the market and correct a misperception with regard to Greenbelt. And I think one of your colleagues raised this. We have, on every one of our sites, 200 or so in Scotland. That represents about 5 to 7% of the market, the property, private sector property market. The open space is well maintained and managed. It's safe and tidy. We record maintenance records on, for example, play areas, play area inspections, sustainable drainage features. And importantly, actually, we record customer inquiry through various communication routes. There's no record of any planning enforcement or indeed any insurance claim against flooding or any credible evidence of anything even vaguely approaching mass dissatisfaction of customers, in our experience. 20,000 customers. Indeed, our customer care is at a very low level. Annual payments are at a high level. We have examples of neighbouring estates asking Greenbelt if we could have the same service as the residents receiving our green space service, as in their opinion, the property values are demonstrably lower given the lower standards of care and amenity land on their developments than Greenbelt managed development. Our experience is we can see a change in the culture amongst owners, and they do see the benefits of well-managed estates, supported by secure legal structures which oblige parties to maintain the balance. Poor management would, I have no doubt, have resulted in Greenbelt being subjected to actions in the Sheriff Court, applications to the Lands Tribunal, yet we have minimal evidence of this. The PFSA has only just been introduced. It's not really had a chance to demonstrate its effectiveness as a redress forum. It's been introduced at not inconsiderable cost to the property management industry, costs which ultimately will be borne by the householder. Any further change will increase those costs. I hope this committee takes on board the evidence provided by Greenbelt, indicates that the appetite for change amongst the vast majority of homeowners is just not there, and that there is a very real danger that if the majority is ignored, and this is a main point actually, if the majority is ignored at the expense of minorities, then the majority will seek to hold the powers that be to account if property values are put at risk as a consequence of removal of a mechanism which ensured a stable and robust way of managing open space on our housing developments in Scotland. I think the point, the main point there is that there is a fine balance just now, and that's what we are expressing just now. And I think it's important to actually understand that and take a full view of it. My personal position is that we haven't heard from the majority of people yet, and that is a danger. If the majority of people actually feel that, you know, there is a good balance there, and the main thing that they have in their mind is their property value, the value of their house. Sorry, I feel as though I've taken
No,
up
yeah,
time.
it's absolutely fine. That's on the record, which allows me to just ask because I don't think you answered Jenny Madder's question about Section 53. How many complaints have you had over, say, you may not have this, but it'd be interesting to know over the last 3 years how many complaints you've had about the service, how many refusals to pay, and whether these are related to the service, and how these are logged. Now, this is not, this is, you fairly said that, you know, the majority of people are satisfied, and most people, and some people even look around to wish we had Greenbelt. I'm prepared to take that as said so, but I'd like to know how many complaints, because I've just heard Jenny Mara refer to, I've had it across my desk, other MSPs have had it across their desk, that they are not having a satisfactory service from Greenbelt, and there appears to be nothing they can do about it except not pay. Now, they're not going to go to court because it's expensive, they're not going to go to a Lands Tribunal, that's even more expensive. So I think in fairness to those people, when you're before us, doing individual cases, if we had figures.
I think, well, we can give figures, and I think, did we submit figures at all? I can't remember if we did in the submission, but the point being is that I know what my figures are, and I know what the level of customer care. For example, at the moment, out of 40,000 UK-wide, We are,
Just deal with Scotland, please. It's
Well,
Titles Bill Scotland, so.
oh, if it's well, in Scotland, well, at the moment, UK-wide, we have 20 outstanding live customer inquiries. Be careful about inquiries because they're not all complaints. They're inquiries about how
I'm
to pay.
specifically
Yeah.
asking somebody who's written to you or been in contact with your
Well-
agent saying, I'm complaining about this, I'm not paying it,
Yeah.
or I'm complaining, this is not being done outside my house.
Okay.
So that really would be very helpful to the committee. And it would also be helpful to have that in written form. I don't expect people to have this data to hand, but if we could have that in written form, and it would be on the website, and other people could see it and say,
I can say to you just now that the level of customer inquiry is vastly dropping down, even though the numbers are increasing, i.e. new billing. We can give you the actual week-to-week figures. We can give you the figures that are this year compared to last year
Yes,
and the year
that-
before. I can submit that. In terms of actually payments, we have I can say to you just now that our collection rates are above 90%, easily above 90%.
that's Scotland.
That's Scotland and England and Northern Ireland.
No, we must have the figures, because we're looking at Scottish legislation.
It's above 90%
It really,
in
we do
Scotland.
require the
Yeah.
data for Scotland, not for the UK.
Yeah, it's above 90% in Scotland.
Thank you, but you'll provide us with additional.
Absolutely,
And
yeah.
your question, Jenny, which I don't think was dealt with, section 53.
Yes, and
Section 53 obviously deals with a very, very complicated area of law, and intrinsically that is the difficulty with it. Very briefly, before the Title Conditions Act and the reform of the feudal system, what we had was a landowner, a householder, with a feudal superior who would be entitled to enforce burdens against them. So, for example, if they wish to make any alterations or extensions to their property, they may need the consent of the feudal superior, who may be an absent individual or an absent company, really with no interest other than to make a charge for issuing the consent. So, politically, obviously, that was a system that had been in place for many hundreds of years.
Yeah.
And as part of the Scottish Executive agenda at the very outset, they felt it was important to reform Scottish land law. And so the Title Conditions Act was one of the part of that suite of legislation. So what the Title Conditions Act did was remove the right of the feudal superior to enforce those conditions. It converted some conditions into community burdens, which are enforceable by all members of, for example, a residential housing development. But the difficulty then with Section 53 is now, previously we were able to identify who a feudal superior was. So if, as a practising solicitor, which indeed I am, if a client came to see me to sell a house, and they needed consents for various works that they had done to the property, I would be able to inform them, we need to approach X for consent, because it would be quite clear. Unfortunately, what we have now is a system of implied enforcement rights, and it's actually, in a practical level, impossible, in my view, to advise a client who is selling a property who would or would not be entitled to enforce certain rights in the title deeds. And that's my fundamental difficulty with it.
And Wendy, is that specifically that difficulty you've just described, is that specifically as a result of Section 53 in the legislation?
My view is Section 53 creates and introduces that difficulty.
And we're conducting a post-legislative scrutiny exercise, so it is kind of open as to where we would go with recommendations. If we were to ask you what your preference would be, would you like to see Section 53 scrapped or amended, or?
Those are the options, I agree. If you amend section, if you scrap it, then I guess the risk is there are people out there with genuine rights, and they may have purchased their property in the knowledge that they will be able to enforce those rights, and that may have been an important factor to them in when they acquired their property. However, the law needs to be clear, and my view is Section 53 is far from clear.
I mean, it strikes me that it's just the legal difficulty with Section 53 is that it is very open to interpretation. And
It is.
It's not clear who has a right to enforce, and then perhaps what interests they would need to enforce. Is that correct?
That's correct. I mean, it's all down to title and interest, and the difficulty is in interpretation of that, because had we been given a definitive list of what would constitute title and interest, then it would be possible to operate Section 53. But the difficulty is we only have examples of what may constitute title and interest, but those are not definitive.
Can you give me an example of what kind of problem Section 53 would cause your company?
Well, in fact, ironically, really we have very little experience of Section 53 operating. In practice, it isn't really terribly relevant for our operation.
Okay, so why does it cause you problems? It doesn't.
What I'm saying to you is, as a practising solicitor in the private, house building industry, if a client was coming into me to sell a property, and one of the things fundamentally you would do is you would check if they have all authorisations, for example, for works that they've done to the property, or they are using their property for the correct purpose in terms of the title deeds. If they have done works, let's just say they've built a garage, who on that development would be entitled to object to that garage having been built?
So you're more giving this evidence as a kind of, with your solicitor legal head on, rather than on behalf of the company, that it causes the company problems?
Yes.
Right.
And I think we'd said that in our written submission, that actually, I have a view on Section 53. Section 53 as drafted in practice for a practising solicitor, in my view, does not operate the way presumably it was intended to. But in terms of Greenbelt, it doesn't have a huge amount of relevance for our day-to-day business, no.
So your legal professional opinion would be for it to be amended?
It can't operate the way it is, so...
And what kind of amendments would you like to see on it? So I'm happy if you want to take some.
Well, I'm just rather concerned. I think you made a very fair point that somebody who purchases a property, either residential or commercial, thinking that they know perfectly well what their duties and their obligations and rights are, that you have an amendment in law because ownership of property can endure for decades, it puts them in an invidious position.
It does indeed.
Because they've lost that security of knowing what they signed up to in the first place.
Absolutely.
Would it be appropriate to say that Section 53 was more envisaged to operate where there was mixed tenure, where you have housing associations, and then the right to buy made it more difficult to know what, who was in this common ownership group, and also maybe perhaps commercial properties, rather than when you have, let's say, a housing estate that's all privately owned with the land round about it managed, then it's very clear what that community is and whose rights.
Well, it isn't actually.
Ah, well, there you go. Wish I hadn't said it there then.
In theory, the community has a right to object if someone is not implementing their burdens. But the difficulty is, if you stay 3 or 4 streets away from me, really, if I make any alterations to my property, is that having any material detriment on your property?
I'm going into planning law there, but I think the point I was trying to make is I thought that section was perhaps to deal with more mixed tenure and also with commercial properties rather than what I tend to think of, which is housing estates, private developments that have, rights of enforcement against each other together with property, the land that's round about them.
No, I don't think it
correct?
was. I think the intention...
Oh, well.
I think the intention was, the community, and that would certainly be residential housing developments.
Roddy to the rescue.
I just want a small piece of clarification. My understanding of Section 53 is it was in relation to pre-2004 burdens under basically imposed on a common scheme.
That's
so
correct.
I don't know how many, in terms of developments, that the Greenbelt Group have got pre-2004 in any event where this would be relevant. Probably quite small. So.
Yeah, the vast majority of our estates would be post that.
So that's one of the reasons Section 53 would be a a big issue for you as an individual group.
Yeah, I know.
Yeah.
Mr Wilkinson wants to come in as well, I think, here. At last you get to speak, Mr Wilkinson.
Would a quick overview of our slightly different approach
Yes,
to
of
the
course, just certainly.
and that sets the context for any of the answers that we give. Ethical Maintenance is a community interest company designed to serve the communities, not necessarily our shareholders. Having said that, we see the factors role as being fourfold: cut the grass, collect the money, look after any special interests, like play areas, sud schemes or whatever, and fourthly, the landowner's interests. We believe in providing a service, you can isolate those 4 separate areas. And the Title Conditions Act, coming back to why we're here today, should enable residents, if they want to do that, is separate out those 4 different responsibilities. In terms of land ownership, which is, we are a land owning company, we do that, or we see that as our role on behalf of the communities we serve, because we are there to serve the communities. So we see primarily the community owning the land around themselves. Most communities that we've got experience with are really not that interested in actually owning their land and taking on the responsibilities. So we're very happy to do it on their behalf. We're also a very good conduit for the house builder to transfer the land to us at the start of a new development. And then later on, we will say to the community, once it's all settled and everybody's happy with the land around them, we say, and would you like to take ownership? And the response we've got so far is they're not that interested. But that, in a nutshell, is where ethical maintenance comes from. I can now go back to the specific question about Section 53 is, well, we're a New Start company in the biggest building recession the country's experienced, so we don't have that much experience of Section 53 at all. So I think our submission says we can see it might be a problem, but we've got no actual experience of it being a problem.
Do you want to come back in, Roddy? Are you happy?
No, well, as a New Start company, I wouldn't have thought that would cause you difficulty. Yeah.
No, but no
Yeah.
further comments in section 53.
Well, I mean,
you seem to understand it really well.
You talk about, no, you do talk about the difficulties for small groups, as it were, of dealing with complex legislation. Would you like to say a few more words about that for the purposes of the record in the committee?
Yes, when we talk to our communities and say, this is the service we provide, 1, 2, 3, 4, do you want to take responsibility for any parts of those services? And on small sites, then actually residents can cut their own grass. We don't have a problem with that. Where they're all work together, they can actually collect their own money to pay for the grass cutting, whether that's buying a lawnmower or paying for a contractor. We don't have a problem with that. On the more complex sites, can they get together to look after the special interests, like setting up a sinking fund to replace play equipment every 15, 20 years? They don't like going there, and they're not that keen on looking after the landowner's interests on the more complicated schemes where you've got big play areas, big sustainable urban drainage systems, or big way leaves that go through the site. Anything that's a bit out of the ordinary that isn't, they're not that keen on taking responsibility for the work that goes on the site. Even if they were keen, to answer the direct question, is do they know how to go about it? And you say, well, we're the factor, we'll help you interpret the Title Conditions Scotland Act. And they say, yeah, but how can we trust your advice? Because you're really on the other side of the fence. And we say, yeah, fair enough. You go and find out for yourself how to do it. And then they come back and say, well, we've looked at it and that's far too complicated for us. And we've sought advice. And the advice that we're going to need is going to be far too expensive. We don't want to proceed. Does that answer your question?
Yes, basically, I don't want to put words in your mouth, but you're basically saying because the legislation is quite complex, it's actually quite difficult when you get situations in practice to be able to reach kind of the right view as to where you should go.
I think I said that in a much more long-winded way.
Yeah.
Can I just pick up on your model is very different from Greenbelt's model, which you're shared ownership and you're outright ownership, correct? What are the benefits of shared ownership that you see, and what are the disbenefits of shared ownership that Greenbelt says? Why don't you follow that model? So if I just put the two kinds of...
Well, we're in business to serve the communities. If you're a normal limited company, arguably everything you do is in the interest of the shareholders and you're there to serve the shareholders. So the two models have, if you like, different strategic aims. Does that answer the question?
You make profits as well then? What do you do?
No, we cover all our costs, and obviously I draw salary and all that sort of stuff.
But you're non-profit.
But we're in essence a not-for-profit organisation, yes. And under the community interest company legislation, then any dividend distribution is capped and controlled. So in essence, our approach is quite different to a normal limited company.
You see, if I tie that into the landowning model that Greenbelt uses, because we haven't raised prices and charges, and I'm noting that Consumer Focus Scotland's research showed that 74% of those surveyed thought the service received was fairly or very poor value for money. A great feeling out there that they're overcharged for it. Now, obviously you've, I take it, you've selected to be a business that makes profits. Is that, which is not a bad thing, it's life. But the problem is that you have a monopoly in many circumstances, and it seems to me to be a perpetual monopoly. Am I misunderstanding it?
Well, I don't know. When did you want to start off?
Yeah, I mean, I think one useful piece of information from the Property Factors Register is now at least that enables us to assess the market share that we have, looking at the properties that are currently registered. And I mean, at the moment, Greenbelt Group represents between about 5 and 7% of of this market in Scotland. So it's certainly not a dominant position, and it's far from being a monopoly.
No, but I mean, where you are operating, you are a monopoly.
No.
I mean, can people...
No, I think I've explained earlier on, there are mechanisms to remove the land management company. We've talked about that before. There is a mechanism there. The issue is there sufficient appetite? Sorry?
Where is that mechanism? Is
Lands
it in...
Tribunal.
Right.
Sorry?
Lands
The
Tribunal.
Lands Tribunal.
Now, there's actually another mechanism as well, which is called consumer choice, which we've introduced, which is well worth having a look at, because when we introduced it, we didn't just knock it up. We actually took professorial advice on it, and
Speaking to professors
absolutely,
next week, and
yeah.
we can
You
find
maybe,
out something. I'll bring you in a minute,
yeah,
Sandra.
You could
Just
possibly
let
ask him about
Mr. Middleton finish.
possibly ask him about consumer choice, Greenbelt, and what involvement he had in it. But it was there. I would suggest it's something that the committee has a look at and says, right, okay, is that a way to do it? Is that a way to find a change? Is that a way to actually, achieve what we're out to do, which is basically get rid of all these sort of misperceptions on monopoly and, overcharging or, masses and masses of dissatisfaction. I'm giving you evidence just now. I can back it up with figures. In terms of coming back to the question, which is basically, yes, we operate a single ownership model. And there are benefits, huge benefits, wide benefits in doing so. When I first started, and this isn't going to be long at all, but when I first started out the company, I was with it was a public sector vehicle, and when we looked at it, the owners at the time were Strathclyde Regional Council, SNH, etc. But when the principle of it was we actually went to the industry and the planning department, and on the premise of Strathclyde Regional Council, which is a strategic planner at the time, they looked for other options which addressed some of the issues that were coming up with common ownership. They addressed some of the issues that anticipated house building boom that local authorities weren't wanted to take on this land. Something that would come up and be a useful mechanism. And single ownership was the reason for single ownership was because sites were getting more complicated. They weren't just a piece of grass in a play area with two pieces of swing on them. They were actually sustainable drainage systems, TPOs, new woodlands, you know, sinks, you know, there was the requirement for art and development. So they were becoming
Mr.
complicated.
Wilkinson, do you not have all that stuff as well?
Yes, we do.
Okay. One of the points I did check with Mr. Wilkinson beforehand is that the biggest size of site he has is about 50 units. Ours is about 1,000. Okay, so there are differences in scale. And, you know, in terms of having a single ownership, the benefits are, I'll give you an example. We've actually been to the Lands Tribunal for one case in which we varied a community burden. And that was on a basis that at the planning point, there was too many play areas designed for the development. 2 had been implemented and 1 hadn't. And we were working with the community. The community was not of young children age class. It was up in Fife. There was and they had an opportunity to say, let's vary this. And we went with the community. We got 96% support with the community. They came with us, and we went to the Lands Tribunal with support from the Planning Authority, with support. It was the right solution. And we went through the Lands Tribunal, and we had a variation on the community burden. That couldn't have happened if there'd been multiple ownership. It could only happen if you had a single ownership, as in me saying, yes, let's go and do this. That's a benefit of change. And the other thing
Test that. Is that correct, Mr. Wilkinson?
What specifically is correct?
Well, the point just being made that only with single ownership could you vary.
I think if the community all work together, then they could. I think the challenge really is getting a community to work together without the leadership of a single owner with the will to go and do it. And I think that's the biggest challenge.
But you could do the same.
Yes.
Just wanted to clarify that. Just before, I've other members want to come in, just want to clarify one other thing. You said 5 to 7% of the market. Does that reflect the number of units that you deal with compared with others? What does that mean, 5 to 7% market?
Yeah.
I mean, there might be lots of other little ones dealing with little estates, but do you have the biggest number of units that you deal with in Scotland compared to others?
Well, what it is we've looked at the Property Factors Register, and we've taken the private registered property management units, households, and basically taken the totals, and we're in a region now. We haven't included housing association, we haven't included the private rented sector. So it's thereabouts. That's our estimation. I mean, you guys can go and look at it.
Wondered what it meant. It wasn't. It just didn't
but it's
quite
in that,
know what
it's
it
in
meant.
that region, yeah.
But I just meant how many units do you deal with
20,000.
compared to
20,000.
20,000. So is there any other management factors that you who deal with 20,000?
I'm sure there are. Yeah.
There are.
Larger. Yeah.
There are larger. So
There are
I wanted to
larger,
know. Right,
yes.
I've got Sandra followed by Jenny, then Graham, then Roderick.
Thank you, Convener. Sorry, and good morning to you. Having listened to you, I've came to the conclusion, and I'm sure it's correct, that you are both land-owning companies.
Yes.
But Mr Wilkinson is more community-minded model, which doesn't make a profit. And obviously Greenbelt are the other company which do make a profit. So I thought I'll get that established at the moment. Pick up on what the convener said regarding the 5 to 7% of the market that you said, and obviously the convener also mentioned about a monopoly, and you had said that no, it wasn't a monopoly, but certainly people who come to see us as MSPs feel that, excuse me, if they're only being allowed, one company to do the maintenance of their area that they live in, it certainly is a monopoly. And you mentioned, I think, Mr Middleton, that there are steps that residents can take, such as a land tribunal, and I'll come back to that perhaps with a specific example. And you also mentioned consumer options. I would like to pursue that part of the consumer options, and perhaps Mr Wilkinson could come in and give me his opinion from his company as well. You mentioned the fact that resident associations can take this consumer options if certain conditions are met. Can you tell me what these certain conditions are?
I can maybe come in and just explain on that. I mean, fundamentally, the main thing that we have to be satisfied on is that if it's a residents' association that we are speaking to, fundamentally we have to be clear and certain that they are actually representative of the individual residents on the development. And that's one of the fundamental requirements. What we would say is we look at every site on an individual basis, and in line with the Title Conditions Act provisions regarding property factors and dismissal of property factors, what we have said is that if there is a if we're satisfied that there is a 2/3 majority in favour of change, then we will accommodate that. That's one of the fundamental requirements. So there needs to be an independent system for ensuring that the 2/3 majority is in place.
The 2/3 majority, obviously, you have absentee landlords, so that's the point where it's very difficult to get the signatures. And also, if you have developers, perhaps even yourself, Greenbelt or others, who have bought up, say, maybe 50 to 60 units within that development, how would that work if you were to get the 2/3 majority?
I mean, we certainly don't have any examples of that across 193 housing estates that we deal with. I have personal knowledge of all the sites in Scotland, and there are no more than, some units where you may have 3 or 4, at most half a dozen in single ownership, no more than that.
I'm not just speaking about yourself, obviously there are other, developments which do have 15, perhaps even more. So I just wondered how that would work with the 2/3, which is obviously 2011.
At the end of the day, we're simply following the precedent that's been set there by the Title Conditions Scotland Act in terms of dismissal of a manager. So there has to be a decision that there is a majority. Where that majority rests is obviously a political decision. Now, in our experience, what we have found is I have a small site in West Lothian where we were presented with basically what we call a doorstep petition, which had been put in front of us by the chairman of the Residents Association. Now, a doorstep petition obviously can be run by a minority, and the perception is pressure could be put on someone on their own doorstep. Do you want to pay? What was the question that was asked? Do you want to pay Greenbelt or not? I mean, possibly 9 out of 10 people would say, I don't want to pay Greenbelt or anyone for that matter. So what was the question? On what are you actually basing the majority decision? So in that particular instance, what we did was we circulated independently all the residents on the development with all the relevant information that they would need to enable them to make an informed decision as to whether they would wish to take over the ownership and the management and maintenance of the features on that site. So we sent them a full information pack, and we gave them a realistic timeline. From memory, I think it was possibly 6 to 8 weeks within which to respond. So that would allow for people who perhaps would be absent, but you would anticipate being able to get a response within that time period. And indeed, when we got the response back, the majority by far were in favour of retaining Greenbelt, and not as the chairman of the Residents Association had suggested. And that was, that was one example of a doorstep petition. And in fact, the residents chairman was not actually acting on behalf of the majority. He was acting on his own interests.
Thank you. Mr Wilkinson, I noticed in some of your submission you've mentioned perhaps it would be a good idea for the Scottish Government to be able to have either a pamphlet or a leaflet explaining the 2003 Act, which would be helpful. So I just wondered perhaps you wanted to comment on that, and also comment on the reply back from Wendy, and how you would pursue.
I think that there's two issues there. One is guidance on how to use the Act. And I'm not sure exactly what. If you're brand new to it and you dive into it, how do I change the burdens to get rid of my factor? Then I've given the example where you have to dance all over between 3 clauses, and actually when you get into each of these 3 clauses, there are references to loads of other clauses, and very soon your average person like me just loses the will to live, and you can't get through it. So that's where the guidance comes in. Actually, once you've spent a lot of time and looking at it, has your factor been appointed by the community, then it's a 50% decision. Has your factor been appointed by the builder, and is he still within his 5 years of appointment, then it's a 2/3 majority. Actually, when you get into it, it does flow quite nicely. But there isn't that guidance there. Maybe somebody should make a fortune and write a book on interpreting it. But anyway, we don't have that book at the moment, and that was why I was suggesting if some guidance could be there. And then you said, could I comment on what Wendy's just said? And that is very much so that you can get a very active minority on a site who want to railroad the rest of the residents into their decision. And certainly we've had the experience on a particular site where it was exactly the same. And then once the residents that realised where they were going, they asked their chairman to resign, and they said, let's continue as we are. So it does happen that minority groups can take over, and we as the factors just have to be aware of that.
There is what I would like to add as well. We have had another ongoing issue on one particular site with one individual who, in a very well publicised case, took us to Perth Sheriff Court, and his argument was that we were not performing the services to contractual standard. Now, we won that case. That was a 2.5-year case. We won that case at the Sheriff Court, both at the first instance and on appeal. We were found to be carrying out our contractual obligations, and so that was good. And what then has happened is that this individual is the chairperson of the Residents Association on this particular development, and he has now subsequently put in a fraudulent application to the Lands Tribunal.
We better stop you right there. I think you know yourself the use of the word fraudulent is, I think we just leave that one if you don't mind.
Well, the application was withdrawn because residents actually came back to the developer, who is still involved with the site. It's an active site where the developer is still building on the site.
I say I'm not too happy about going down this. I appreciate you're trying to make. I think you've made a point. I think you've made a point that we sometimes have a minority that can be vexatious and misplaced. I'm not saying that's always the case, but it can happen, or an individual. I think you've made the general point that you're not baddies, you know, per se, and there might be issues sometimes with some residents. So I don't want to go into specific cases, and so notwithstanding there was a certain anonymity, I'm sure people can probably work out what it was. I think that point's been fairly made, Mr. Middleton.
Well,
frankly.
there's actually something that might be very helpful for the committee.
I wonder.
And, yes, absolutely. One of the issues with the consumer choice cases that we've had I think it's 13, and which in every case we were quite willing to help the body of people who were seeking a change. The one issue, and this is the issue I've emphasised it at the beginning, the issue is who's going to take ownership of the land at the end of it. Okay. Because you know the issue is you want to remove the land management company, but bear in mind we still own the land. Okay. And there are certain rights, obviously, from a landowner. You can't just toss them off the land. So who is going to take it over? In every case that we've had, we've got to perhaps that point and then say, well, who do we transfer the land to? You know, we're quite happy to set up the legals and transfer the land, just to let me know who the signature is. And in any one of those cases, despite what Kevin was saying, and the difference is Kevin is dealing with fragmented land, so you can pick and choose. From our point of view, you're dismissing Greenbelt, and therefore, fine, we'll walk away. But tell us who's going to take ownership of the land. And there aren't very many people out there that are willing to take ownership of that land, whether it's the grass, the suds, the play areas, the liabilities associated with it. And that is a crucial issue that you have to get around.
Can I just sort out, so ownership and management are not separable for you?
What incentive is there? I mean,
it's fine. No, I'm just making the point. They're not separable, and that's part of the issue. Is that if people are discontented with the land management, the issue of ownership is on the plate. That's what's in front of them.
Absolutely,
it's really it. Yes.
Existing legislation, as it sits, doesn't address that at all.
No, I mean, I'm just testing it. That's exactly clarified for me. Graham, please. You've been very patient. Followed by Jenny. So, I beg your pardon, Mr. Wilkinson. Yes.
Management and ownership, there is an argument that they're not separable, but we see it the other way around, that they are separable as long as the landowner's responsibilities are properly looked after. And that's for us, the challenging area.
Yes, but for Greenbelt it isn't. That's
Right,
just the
that's
point,
fine.
which is fine. Jenny, no, it's Graham, sorry, yes.
Thank you. I go back to the Consumer Focus Scotland report, and I really just seek a response from you in terms of the conclusions. It seems to me there are three conclusions that the report draws attention to. One is about the confusion over services, responsibility that the landowning company management have for public liability insurance, inspection of facilities and liaising with other bodies. They feel there's a confusion there. The second one pertains to value for money, and that the land management costs are justified. And the final one for me is communication, that they feel that the landowning land management companies are either fairly poor or very poor at keeping them informed. It seems to me that if these three issues are responded to in a positive fashion, many of the friction areas between the tenant groups, the owner groups and yourselves might be eliminated. Are these fair comments? Do you recognise the comments? Would you offer any view for the future?
Yeah, I think that they are comments that were made. Wendy's already referred to the Consumer Focus Scotland survey, 2011 or 10. I can't remember what it was. You know, again, we had question marks about the template. We worked with Consumer Focus Scotland in Ipsos Mori, and we weren't satisfied with the survey because it didn't address some of the issues that we felt needed to be addressed with. When you have to do a survey in the context of a bigger picture as opposed to a smaller picture, you can do a survey and say, do you like Greenbelt or not? No, fine. Why? Value for money, first thing that comes to your mind. That was our view of it. Okay, and I'm being honest about it. 2013, we've got the PFSA, it's standard, we meet it. There's written statements, it gives us an opportunity to demonstrate to the market, to our consumers, you know, we actually comply with are compliant with the current legislation. So in terms of value for money, that's addressed by market tendering. In terms of the services, that's addressed by the fact that the written service statement of service highlights absolutely everything consistently. With regard to communication, we have free phone lines. I've talked about the customer care. We can demonstrate that. Bear in mind that that's our experience. You can take our evidence or leave it, but that's our experience. You've invited us to give us your evidence. We're quite happy to give it to you. Just to come back to the point about confusion, I think that's another. That's a separate issue, which I believe that the recent legislation, which is only recent, should allow basically a dilution of any confusion. I think if there is confusion, then people know to call us and say, what's the situation here? What's the arrangement in place? And bear in mind also the house building industry, because the house building industry has had to basically take a responsibility in informing people of making the biggest purchase in their life. And that's something we battered into the system. And, you know, in certain cases, we wouldn't take developments on because the residents hadn't been properly informed. And, you know, we passed them back to the developer. Mm-hmm. That's not a very helpful situation if you're a resident. You're caught in the middle between something. So, in terms of confusion, yes, absolutely. I think the PFSA has actually, you know, diluted it or allowed it to basically not be an issue anymore.
Okay. Mr. Wilkinson?
There were 3 points, and I remembered 2. Communication and value for money.
Sometimes I just remember one.
The confusion of the services, it was that element of public liability insurance and other issues.
Well, that's,
that was the 3.
We certainly get that feedback from residents that have not been prepared to engage with us. And that sounds a bit aggressive, but basically we meet with our residents twice a year, once at the end of the year and say, how did it just go? Do you want us to do anything different next year? From that meeting, we put the works programme together for the following year and say, do you want to do it yourselves? Have you got any contractors that you could recommend us to use? And these are the ones we're going to go to. We then go and get the work programme together, tender it, and then we come back and we do open book and say, here's the tenders. this is what the contractor's charging, this is what the insurance is, this is our overhead that you have to pay for us managing it. What price do you want? Because it all works out from that. So we would say for those that are prepared to engage, then there is no issue. And as Wendy and Alex have said, now through the Property Factors Act, every year they get a statement of it, how it's all worked out and what all the ins and outs of it are.
So is there a feeling from what the two of you have just said there that there might have been some evidence that supports these views, but developments since have gone some way to repairing the situation? The bit that I'm not particularly convinced of, I've got to say, is that at the end of the day, you provide a service to these areas. Inconvenient as it might be and frustrating as it might be in trying to provide this service in a way that your customers would seek, we need to see that endeavour, that energy and take it forward. I pick up on Mr Middleton, a frustration there in terms of administering this business, and I can understand that, but you've entered the game of providing this service and you need to take the downside to that.
Absolutely, and I think you're absolutely right there, and I don't hide away from that at all. There is, just to make a point, I think in 2007, 2008, I think, I actually personally held my hand up and said this company got it wrong. I had a couple of MSPs that were all over my back. Maybe I'll rephrase from that, but anyway.
It's characteristic, I think.
No, absolutely, and I held my hand up, and the first thing I did was I pulled all my staff in and said, look, we are not a company providing a facilitation mechanism for the development industry, no more. We are a service provider. So we have to change overnight, and that's exactly what we've done. Since then, what we've done is brought in things like, for example, consumer choice, which we did. We brought in customer care charter. We've brought in a dispute resolution, which the PFSA, actually, the Scottish Government actually asked us, could we have a look at yours? We brought in, various other, they're all advertised there on our website. It's about developing a service, and, we're not there yet. And what we'll do is we'll keep on improving. That's a desire. You talked about the energy and the desire. In Greenbelt, that's what I absolutely dig into all the staff. They are loyal, but what I do is also protect them.
Okay, thank you.
I just want to add on balance to Greenbelt, if you would also provide us with complaints over the past 3 years that you may have had and non-payment and so on. I think that's in balance if we're looking at the two systems. Can I move on to Jenny, then Rod?
Thanks, Convener. Can you help me understand this? I understand that a developer can register a deed of conditions before they transfer the land to the maintenance company, but that deed of conditions can specify the maintenance company, the name of the maintenance company that will take charge of that land. Is that correct?
Yes, that is correct.
Okay. And how much of your business comes that way, that the developer has decided that Greenbelt will be the maintenance company and that is in law?
What I would say is, and I mean, I am heavily involved in the drafting of that wording.
Yeah.
At the time, the developer has to put the deed of conditions on at the very outset. There has to be a mechanism in place for the ownership, management and maintenance of the open space. The deed of conditions has to be put on before the first plot is sold, because that's the way legally the mechanism works in Scotland. Mm-hmm. And as part of the House Builders Code of Conduct, also at point of sale now, the developer has to inform the house purchaser on a new development what the arrangements will be for the open space. Mm-hmm. In terms of the actual wording, on many occasions Greenbelt Group will be referred to in that deed of conditions, but it will be Greenbelt Group or any other body that may be appointed to take over the ownership and management and maintenance. Mm-hmm. I cannot recall an example where a developer would be willing just to have Greenbelt Group in the actual wording for the deed of conditions, because at that point they may well not have actually signed a contract with us to take over the estate. So they are still looking for the flexibility. They may have decided that it's a single ownership model. first of all, they won't just have Greenbelt Group in with no other option. I'm almost certain of that. And secondly, they may also put a factoring alternative into their deed of conditions so that they reserve the right to do either or.
So, you said you had 193 estates across Scotland. How?
That's correct.
Yeah. How many of that 193 have come to your factoring company by virtue of a deed of conditions from the developer specifying that you must be the maintenance company?
I would say almost certainly nil, I would say, because Greenbelt Group will not always be named. They may be named, but it may be Greenbelt Group or any other or another body, if the developer reserves the right to convey the land to Greenbelt Group.
Okay, so how many of the of those 193 have Greenbelt Group been specified in the deed of conditions as one of the potential maintenance companies?
I would need to check, obviously, on a site-by-site basis. I don't have that information to hand.
And
But there are obviously developments where Greenbelt Group are specified, yes.
Is your group a developer and a factor?
No.
No, right.
We're not a developer. We are a land management company. We don't do development. We are. We provide a service.
Okay. So, sorry, my final question on that. Are we saying that the 2003 Act allows for development companies to hand over maintenance contracts to the maintenance firms that they prefer through this deed of conditions?
Sorry, I'm not quite sure.
Okay, sorry, I'm not explaining it very well. Does the 2003 Act allow, by virtue of this deed of conditions, allow developers to say, right, X Holdings, X factoring company, we'll give you this business?
I don't think so. Does it?
It does.
Well, it is possible to do that, but I mean that's really in line with what the development industry has, the way it has developed as part of the House Buyers Code. I mean, residents have been confused; they've had lack of information, and the 2011 consultation partly covered that. Residents wanted information at the outset, not to be given information at the outset when they're purchasing their house.
No, I understand that, but it seems to me that there's a situation that the Act allows for, that when you go in to purchase a flat in a development, the developer themselves can decide and give the business for factoring to a specific company. Is that right?
Well, I think what they're doing is, I mean, I think probably PFSA might actually put a wee bit more meat on this, but I think they have to demonstrate that they've selected the right.
Yes, but the Act does
factor.
allow for that. Is that correct?
Well, I think in terms of the business and how the developer decides, along with the planning authority, how the long-term management and maintenance, whether it's a tenement or an open space, will happen.
Mr. Mitz, I'd really like a yes or no answer to that question. Does the Act allow for the developer to decide who the maintenance company will be?
Yes, on both fronts. The developer can choose the maintenance company and put it into the title deeds, or they can say nothing in the title deeds and then they can still appoint their favourite maintenance company.
Okay.
Okay. And then it's very difficult for the residents at the other end. The 2/3 majority is there, but it's still difficult for them to get out of the factor that the developer has initially decided on in those titles.
But you have to remember also that...
No, it's, we can come on to what I have to remember, but is that correct?
Well, our submission is yes, because they can't work out how to get through the Act to do it.
I'll give you an example here. I think possibly this is where you're coming from. The answer is yes. The developer can decide, along with the planner or whoever else he confides in, as to how or who is going to do the long-term management maintenance of the open space. The reason he makes that decision, or the considerations he makes, are, first of all, one, is it a 500-unit development? It's quite complicated, which involves, I mentioned to you earlier on, the size of developments have increased over the last 10, 15 years, and they encompass areas in the green belt which might be protected, it might be, water, it might be drainage, it might be floodplain, or whatever it is. And who's going to take on all that? And we're a company that do that. I think, between what you're doing is you're sitting at the two guys that actually are quite willing to take on this type of land and look after it. Whether we do it well or not, we're still learning. But we're willing to do that because there's not many other guys out there, whether it's the local authorities or whatever, that are willing to take this responsibility. And when I talk about
Yeah.
responsibility and
I
land ownership,
appreciate that.
I'm talking about public liability insurance.
Yeah.
The SUDs, putting the insurance in place for the SUDs, so that if there is a flooding damage, we have the data that the insurance companies can look at and say, right, okay, we'll pay out on it. That's responsibility. So in terms of actually who's going to be out there, who's going to have the experience and expertise to go and manage this site, that's what the developer will make his judgment call on. If it's a relatively simple site, which is just a piece of grass and a couple of shrubs, then they might have a wider audience or a wider group of people that they could choose. But if it's more complicated, then they look at Greenbelt, because we have got that's something to recognise, we have got the mechanisms and the systems and the expertise and the knowledge to manage big, wide, complex developments.
I think Jenny's getting at is...
Sorry, I was getting off on one there.
No, it's okay. I've not got a microphone. I think what Jenny was getting at, forgive me, Jenny, if I got this wrong, is that the developer appoints the land management company, and that's it. And that you're nodding, so I'm taking that to be the case. So there might be concerns that there's and I'm not impugning anything, but there may be a very close relationship between developer and land management company, and in the middle are the people who are living there, who have no say for whatever seems a very long time, and I accept you're bound with the legislation and you temper it, which is absolutely right, but are bound with that land management company, whoever that may be. Is that a reasonable summation?
I think in terms of, I apologise for that, Ms. Mayor, I think it was maybe just not quite, maybe there's a wee bit of frustration coming out, but I think...
I didn't hear you, so I don't know if...
I think that from our point of view, actually, that is not our decision. We are called and said, right, okay, would you like to take this site on? We'll have a look at it.
I just was making a point, summing up the relationship that is there and perceived to be there. Because my question would be, how many sites have come to Greenbelt because residents voted for it?
Interesting question. I have examples of sites where residents on Greenbelt energy sites, where there is no mechanism in place. It's just a straightforward landowner. They have asked for the green space service, and we have looked at it in terms of, can we appoint a factor on it, or can we
but
set
how
up
do you
something?
hear my question? If you can't answer it, that'd be useful. And the same question I'd pose to Mr. Wilkinson. How many of your sites are you there because residents voted for it?
Right now, none. But over the next couple of years, then where builders have retained ownership of the site, we're on a 3 or a 5 year appointment. At the end of that appointment, then the residents get to say, we will go to the residents and say, do you want us to do another 3 years? Yes or no. So if you ask me that in a couple of years' time, it'll be an interesting answer.
Is that regulation, that 3 or 5 years say, Mr Wilkinson, specified by the legislation, or is that something your company has decided to do?
No, that's something that the builder decided to do.
Right, that's right, okay.
Well, I'd like to let Roddy in because you've been terribly patient. Then I'll let Sandra, I'll let you in. But Roddy, I'll let you in because you have sat patiently while I've jumped in.
A number of the submissions we've seen suggest that a real burden which requires homeowners to pay for the maintenance of land in which they have no ownership interest is unenforceable. If that were to be tested in some way at the Lands Tribunal, what would be the impact on your business?
This was an issue that we were aware of almost really at the outset, and indeed we took advice on that particular element, and certainly in terms of the Greenbelt Group Limited Deed of Conditions wording, our residents do have a servitude right to use the ground for access and egress and for recreational purposes. So in terms of our wording, the residents do have a right in the land. They have a right to use it.
Okay, so you're saying that distinguishes it from the submissions because of that servitude
Yes.
right? Yeah, okay, I take the point. Yeah, okay. So it's not a matter of concern to you then?
It's not a matter of concern, no. Okay. It's an issue that we addressed, right at the outset when looking at the mechanism.
Yeah, okay.
May I suggest that we give you a copy of, I suppose, a standard deed of conditions? Greenbelt standard deed of conditions.
I think we've obtained that.
I mean, that'd probably be quite useful for you to look at, because...
If it's on your website, is it?
Don't think we
No,
put
there
it
would
up.
be one on the
Send it to
website.
Clark's, please. That would be fine.
I don't see many customers actually going and looking and finding a deed of conditions quite exciting. So
Lawyers might.
Sandra.
Small follow-up. Can question yourself and Jenny were saying, I'd just like some clarification on this particular point. Would you say that in the case of developers, they have problems perhaps with planning authorities and even lead developers pushing forward for, land owning maintenance model? Because I think that's the crux of the matter, where we're saying they don't necessarily say greenbelt, they can say greenbelt or another, but is there a problem there for, maintenance of land, common ownership, even that local authorities, planning departments and leading developers would recommend companies such as your own?
I think, that's possibly where we were before, just that there are cases and that happens. What I can say just now is that, I've mentioned that we're a UK-wide company and, most of our business is in England. So we're not necessarily actively promoting Scotland. So we're not there readily available.
I'm asking you a question about, it's just to clarify the point that was raised by Jenny and the convener as well. I mean, I know we've spoken about it very much, but if it is a case that local authorities and leading developers are recommending that when you go ahead, it's a land owning maintenance model they wish to see, then certainly it would be skewed in one way rather than the other.
There's really only 2 or 3 of us.
I'm just asking the question, is it the case that local authorities...
I don't think so. I'm not sure. This is decision making that I'm not party to, with the developer and the planners, etc. I'm aware of discussions, but that's not really what...
Wilkinson?
Honestly, not a question, perhaps, Mr. Wilkinson. But Mr. Wilkinson, have you any experience in this?
I'm trying to work out if it's really... The local authority wants to be sure that the long-term management of the landscaping is looked after. And the local authority says to the builder, how are you going to convince us that you're going to do that? And both the builder and the local authority know that if you give it to the residents, you don't necessarily guarantee the long-term maintenance of the site. Whereas the landowning company maintenance model does guarantee that. So I think I'm not sure, I don't think I've answered your question directly, but I can see why builders do propose the landowning model to local authorities, because it secures what the local authority wants.
It just would be interesting to see if it's a recommendation under conditions and planning enforcement, which would basically say that local authorities have to look at this also, if they're recommending land maintenance owners, companies.
Yeah.
Just considering we haven't got any planners coming for us, but we can certainly put it to the academics, whether that's their experience, whether it's all kind of a triangle that's connected. Well, triangles are connected, aren't they? It's not you next, John, so don't look optimistic. It's 2 short questions because we've had a fair bite at this. Colin and John, if you come in early, you see your questions aren't short.
Thanks, convener. I wonder if you could tell me, how do you decide on what is an acceptable level of service?
You're probably...
That's set by the builder in agreement with the local authority. In that, and largely we're talking about landscape maintenance, but also it applies to, well, I don't know if the local authority sets the cleaning of the common areas in flats or not, but as far as we're concerned, the local authority says the grass will be cut twice a month during the growing season, the shrubs will be looked after. And the builder says, this is what you've got to do. So we then say, to do that, we're going to charge the residents this, and that's how we go about it.
It's a good question. That's the question that comes up all the time in terms of accountability. How are you performing? The specification that Kevin is referring to is it's a performance spec. It's a minimum spec. It's probably inflexible. It's set out by planners as a kind of security in terms of making sure the site is maintained. It will refer to landscapes, hard and soft. It will refer to woodlands, young and old. It will refer to suds, and it will refer to play areas. On top of that, also, one thing you've got to remember is that this country is heavily legislated in terms of European law. play areas, drainage, you name it, woodlands, etc. now as well. And, as well as specifications, there's also legislation that we have to follow. And, there is a lot to consider there in terms of making sure your performance and your specification. But ultimately, what you want to do as a business is you want to have everybody satisfied, because it's easier that way. It means also, I talked about earlier on, we've got payment rates of maybe over 90%, 92% on average. There's 8% there that are benefiting from not contributing. But the difference that 8% is? The 8% is actually the difference between perhaps, your standard average, maybe just above average, and perhaps Hanging Gardens of Babylon. And that's what the whole development gets. And that's the irony of it all, is actually if the non-payers that are a very small minority actually do contribute, then you get better. Because at the end of the day, it's actually, as a business, it's actually easier to have everybody satisfied, and let's move on and look at some of the other issues that come up. Because on developments, the type of customer inquiries we get on developments are maybe 5 or 6 or 7 years old. Like the landscape's all established and everybody understands about it. It's like traffic calming, or what about where the lollipop man stands, or the bus service. That is part of community. We can help because we have connections in the development side of things, and also in the planning departments, and also with the political sector as well. So yes, we can do things like become part of the community. So there is an incentive to get to that point. So your service provision is a basic. Let's get up to the highest point possible. Let's get the customer satisfaction up to the highest level possible, because then you're moving in. Because as a landowner, you're effectively a neighbour to all these other residents as well. You're part of the community. So naturally you're going to be part of, a major influential part of the community in terms of finding solutions. And that's very much where you want to get your business to. And that comes with longer term. And we've got a lot of record of that. You're very welcome to come and look at some of the interesting stories. Look at them on our website. You see some of the interesting stories on them as well. When perhaps we don't market that enough, we don't sell that enough, we just get on with it. But performance, service, yes, absolutely. Get above the minimum spec as quickly as possible, because that's what business is about, and service provision is about.
It was a short question because she kept to the end, but I'll let you have another short supplementary. We really do have to have a next panel. No, if it's eating away at your soul.
No,
it's not eating away at your soul. Right, John, perhaps you'll come in first next time, and John, you'll come in second.
Thank you for that guidance, Camilla. Yeah.
Or you can come in first, as the case may be.
Very kind, very kind. It's a question, or perhaps more a comment to Mr Wilkinson, and I have to say I wasn't necessarily going to raise this issue, but we've skirted around it a bit. So my comment is this, and then I'll maybe a question after it. There are a number of private housing areas which are maintained to the householder satisfaction by the local authority. And basically you gentlemen are in business because local authorities have disregarded what some might see as their obligation to maintain space around households, and I include not just registered social landlord council houses or private developers. Do you have any discussion at all with planners? Because my preference would be for the local authority to be undertaking the work, I have to say. Do you have any discussions with planners at all?
Short answer is yes. The long answer is doesn't really affect. Our discussion with planners are where we're going in to sort out other people's failures. So we do have discussions, we do know them, but not towards them saying to the builder, give ethical maintenance any work.
Okay, thanks very much.
Let me just add, that's a very good point actually. Do we discuss with planners? Absolutely, it should be joined up thinking. That's our view about things. Because one of the things that we can offer as a long-term landowner on sites that are basically, development sites, highly sensitive, motions run high. There's also a lot of value puts into them as well. And it's probably in terms of actually all the different factors that go into a square metre of open space land. It's the most important piece of land around. And it involves so many people. But yes, the planners should be involved in that. Our role, I always see, is not about influencing whether we take it on or not. It's actually about getting the design right. And we can basically bring back some of our feedback and experience in terms of design and saying, I referred to one earlier on, which is Balmullo. You know, why would you have three play areas that are for kids when you know the profile of the residents is actually all over a certain age? Can you change that? Yes, you can. So it's about design and getting the feedback in and saying, don't. If you do this, this is what's going to happen. Or if you have shrubs around a curb with a parking place, then you will naturally get, when those grow up, you're naturally going to get people saying, by the way, my trousers get torn, and my skirt gets torn, etc., etc. Put different kind of shrubs in. Or the biggest thing about a development site is actually, it's not virgin land when it's greenbelt. You know, that land, every inch of it has been turned over by a digger and flattened. And so when you come to actually do the design, and when you have to establish the development and establish the open spaces and the green spaces and where you put the play area, maybe sometimes play areas are actually flexible as to where you put them in. It's just a case of when the developer decides they're going to put that play area in, and they always leave it to the end. Put conditions in that actually say, well, let's get the play area in early, so everybody knows there's a play area there. There's not left to the end. That's the sort of advice we like to put into the planners. Not because we want the business, it's just actually part of the whole entity of it, and saying, okay, let's get the designs, let's get the impacts, because the one thing about
the play areas are invariably put in an unfavourable part.
I don't want to go into an inquiry into too many play areas in the wrong place. I do want to bring this. I've had to go about the planners and whether the involvement should be earlier with yourselves and developers. I do want to. I'm so sorry, John, but I'll let you.
Can I just clarify then? We will be, since this area has been opened, I think further exploration of the role, because very, very briefly, planning authorities, and I speak as a former councillor on a planning authority, impose considerable conditions. Probably the one that has the most lasting effect is the one about grounds maintenance.
Yes. So if you want to write further on that, I'm sorry to curtail it, just we have another panel of witnesses who've been very patient with a long agenda in front of us. I just want to caution you, don't plant a high hedge. So on that note, I'm going to suspend. Thank you very much for your evidence, and you're getting a 10-minute break. And then witnesses who waited so long, you're getting an extra bit of a break. So you can have a cup of tea. You've waited a long time. Just, right, jollity over. Can it be jolly in the Justice Committee? Of course it can. Can I welcome our second panel of witnesses to our meeting, and thank you very much for your patience. That was a very long session. Alison Brine, is it Brines or Brines? Brines, Scottish Federation of Housing Associations, David Dorn, Director, Hacking and Patterson Management Services, and Jennifer Russell, Managing Director, Your Place Property Management. Sandra.
Thank you very much, Kevin. I'd like to declare an interest as Hacking and Patterson are my factors, and Mr Dorn was one of the factoring people when it was based in Glasgow. So,
thank you for putting that in the record. And questions, please.
Very briefly, sorry. I am here representing SFHA, but I'm actually from TC Young Solicitors in Glasgow, and I act for the majority of housing associations when they have factoring queries. So I just wanted to say that before anyone fires any statistical questions at me that I won't know the answers to.
That's a shame. We had so many statistical questions. No, not really. Right. Would you like to start, John or Colin, with your questions?
Questions? Well, yes, yes. Thank you, Convener. The panel members were all present at the previous panel. I wonder if you would like to comment on what you heard, please.
Any particular aspect that you feel an urgent need to comment, please? Just self-nominate. Who would like to say something first?
I'll certainly.
Right, Miss Russell.
I'm Jennifer Russell. I oversee the property management for Glasgow Housing Association. Cube Housing Association are also part of the GHA group and also deliver a factoring service, so give me a wee bit of experience about that. I suppose in terms of the 10 questions that we've heard, there's 3 areas that were of particular interest to us as a housing association and a provider of factoring services to some 24,000 for GHA and another 1,200 for Cube Housing Association. One of them was around private development, and that was around the interests of the owners against the interests of developers, which were part of the earlier discussion. The dismissal of a factor, whether or not it was workable in the 2/3 majority and the size and scale of developments, and whether or not that was a barrier or whether or not it was an opportunity. And we've had personal experience as a factor from that. And also of a purchaser of buying into private development properties very recently over the last 18 months when we've purchased properties for mid-market rent opportunities. So I suppose from...
Sorry, can I just clarify, are you suggesting that there was a maintenance regime in place when you did purchase these properties?
No, there's not, and I was just going to go into our experience around that. You know, questions 2 and question 6 that were asked were around about, do the timescales strike the right balance between homeowners and between the interest of developers? And question 6 that you asked us was really around, are there provisions workable in practice? For us, the terms in there, the 5 years for private developers and the 3 years for care provisions in general actually do work, because it takes that length of time, I think, for a private development to mature and to develop. The 2/3 majority, though, about whether or not homeowners can actually, if they're not happy with the service within that period of time, my understanding of the Conditions Act is that the overriding power to dismiss doesn't apply to a manager that's been appointed under a management burden until that time lapse has actually elapsed. So for us, people are actually bound by that 5 years. So if they're not happy with the factoring arrangements within that period of time, they can't do anything until that time lapse or that period has elapsed. One of the experiences that we had when we actually purchased in one of these developments is that very often, more often than not, these days, a lot of the developments aren't fully developed out. So you might have phase 1 of a development being completed and phase 2 just put on the back burner because there's just no interest in the purchase of them. That in itself brings complications, because what we've found very often, more often than not, the developer continues to take on the responsibility of maintaining the common areas rather than actually the appointment of the factor, which they absolutely do. And their interest is very much about making sure that it's in a good condition so that they can sell it. But where they stop building and the roads aren't fully developed and the common areas aren't fully developed out, then, if you like, as an owner, an individual owner and the individual owners in those developments, they're almost in a no-man's situation. And that's where, one, we have frustrations because we're buying into those developments, and two, as a property factor, when we're personally approached from owners in estates that are in that situation and they're not fully developed out, they're asking us to take on those factoring services on their behalf, and they're bound, they can't get out of the 5 years. 2/3 majority in an estate of 100, 200, 300s, it's almost impossible to do. We've had lots of public meetings to try and support homeowners to move and to change factor at our expense. It's resource hungry, and it's quite a difficult thing to do. So I suppose, in hearing what I heard earlier on, I suppose my message is we absolutely need to make it easier where there is difficulties, to actually give people the voice and to give them the opportunity to make some changes in the factoring arrangements. One of the areas that we've came across is where there is residents' associations and active residents' associations, is that yes, they might lobby and they may have an ambition or a power, and a hunger to actually do something about it. And then when you get to the voting, they have the apathy, and not everyone sees it as a priority. They don't have, if you like, decision-making powers. And if private developments had a committee that actually had decision-making powers, then that would maybe make at least the debates and the discussions easier.
Can I interrupt you there? Because perhaps my earlier intervention wasn't clear. Can you help me with the chronology of here then? As a registered social landlord, you're acquiring properties on a private site for you to rent, park, sale, whatever. And
as part of the Glasgow Housing Association group, as a housing provider, we're purchasing properties as part of our housing options model.
And as part of that, you're inheriting a grounds maintenance obligation when you purchase these?
No, not at all. It's not connected to our factoring activity. As an individual owner,
I'm sorry, I should have clarified. As the person acquiring these properties, and albeit that you are factors as well, you are not yourself factoring them. You're inheriting an obligation from someone else.
Yes.
And the site's not complete, and there's no discussions with you about that or the opportunity for you to take on the factoring?
No, not at all. Because it goes back to the conversation that you had earlier, that the developers will actually appoint their factor within that 5-year period of time.
Have you ever been appointed by a private developer?
Not under those circumstances, no. No.
Okay.
I think it's interesting you raise these part developed sites. There are huge issues about these which we haven't addressed. Does anybody else in the panel want to address the issues raised by John?
I'm David Doran from Hacken and Patterson. Obviously, and we're the simple factor, should I say. We have no ownership of areas or ownership of land or ownership of property within any developments that we factor. In that sense, we would look at it before it gets to the legislation, and I think that's what we would urge, is that the legislation's in place as a kind of back, the last resort as such for owners, and we would look to try and get the owners satisfied or a resolution process in place before it gets to the need to look at the legislation, to change burdens, to remove a factor. And I think that's where the committee, where the Scottish Government really need to be looking at in terms of getting factors and owners talking together. Jennifer talked about residents' associations not having any clout, as we would say, or an official. They can have. Most modern title deeds these days have the procedures in place to put in a formal committee of owners who therefore take over, are empowered to take decisions on behalf of the rest of the owners. Now, ultimately, there is problems in getting groups of owners together to do that, but that's more to do with the will of the homeowners rather than anything else, or the legislation behind that. So in that respect, the owners do have a certain level of power. The Property Factors Act is going to help let the owners know that they have that power more than anything. I think it's going to offer a greater level of transparency and open the doors for owners and factors to get together and discuss and to empower themselves. But in terms of the situation as it is and referring it to the legislation, we need to look at getting it before it gets to that situation where the homeowners are having to go through the legislation to get action on the developments. We talked about developers appointing property factors prior to a deed of conditions being registered. Our experience in that is it's similar to appointing a contractor. There's a tender process that goes through, whereas a property factor will put together a tender based on the information provided to them by a developer. And it's the successful tender that is therefore appointed the property manager to look after the maintenance and that manager burden. That tender document in itself can take a lot of work because it can involve extensive planning conditions for the maintenance of woodland areas, for suds ponds, and therefore it's the developer makes a decision based on that tender, not only based on that tender. I can imagine they base it on their experience of developments as well and how factors have performed in other developments that they have passed over to them that have been successful tenders. So whilst they have the right to appoint a factor, it does go through a process to get to that stage.
Thank you.
Sandra, sorry, I beg your pardon, yes.
I think from my client's perspective, they come at it from a slightly different angle, in that the majority of my clients see factoring really as a necessary evil. They don't see it as an enterprise to make money. My clients really end up being a factor because a property sold through the right to buy process, or where they've developed out a new build development and maybe sold some properties outright. There's maybe sold some properties through shared ownership or shared equity, and they are appointed as the factor within their own deed of conditions. So we don't really go through a process of trying to establish ourselves as a commercial factor and going out to approach new build developments to take them on. So that's slightly different in that respect.
Sandra, you were wanting to come in?
Yeah, yes, Convener, just to follow on from that, I mean, you're talking about a new private development, and Jennifer has alluded to that, basically how you would like to see it run regarding factoring. But the fact is, for the first 5 years of that, a factor is appointed to look after that building or whatever it may be, that development. And then the only way, if it hasn't been, there's nothing that the residents can do about that in the first 5 years, because that's tied into title deeds. After the 5 years, if they're not happy with the way the development, with the service they're getting, then they have to go and look for a 2/3 majority, which is difficult. And I think I said...
but I don't mind.
Oh, sorry.
This is absolutely fine. I'll move you over there as one of the people who has a property factory.
What were their thoughts on this? Because basically we're looking at this to see if this legislation is working. And I think the evidence we've received, certainly there's something that needs to be looked at once again and maybe changed. So you've got the 2/3, or basically if you've got absent landlords, how do you get these absent landlords? And in the case of huge developments, I'll give the example of the Harbour development in Glasgow, in my constituency, where they are factored and owned by factors as well as, and they're factored in that respect. So it's very, very difficult, I think anyway, to get into the 2/3 majority, etc. And I just wondered if the panel, and I know what Jennifer's already said, so perhaps she won't comment on that particular one, but what the panel think of that. Do they think, yes, that's fine, if RSLs even own the majority within a development, or if private developers own a majority, or factors own a majority in a development? Do you see any other way that, really the residents, as I can see, can get justice? Or is it only the 2/3, or is it going to land tribunal? I mean, how else could we do that to give residents satisfaction if they're not happy with the service that they receive?
Well, I think I've worked quite a lot with the property, the Homeowner Housing Panel with the new Property Factors Act, and looking at their resources and what they have to look at with factors and the services that they provide. And I think that does plug a gap, where if you are not satisfied with the service that you're getting from your factor, you have someone that you can now go to raise that as an issue and a query. What the Homeowner Housing Panel does not have, though, is a locus to look at costs. So that's something that's entirely different. You cannot go to the Homeowner Housing Panel and ask someone whether a charge of £50 to change a light bulb is appropriate or not. They simply won't look at a query in relation to that. But in relation to the provision of an actual service, they will look at your duties and what's set out in the titles, if there is anything in the titles, and what's in the written statement in terms of your undertaking to owners about what the services are that you're going to provide.
So there's something else.
Can you pick up on if there's any particular difficulties when there's mixed tenure? You know, a balance either way, social housing, housing association, people who've bought under right to buy, or the balance is how does that make particular difficulties where maybe one team's on one side saying, well, I'm not doing it. You know, they're renting houses, the housing association want this done, but I'm not paying for it. You know, does that cause special problems?
That's one of the main concerns for housing associations, where you have a situation where you're trying to encourage owners to participate, especially just now where lots of organisations, because there's a lack of development, are looking to things like major repairs programmes, where they're identifying things like re-roofing that needs to be done, things that are substantial costs to owners, and they're trying to encourage owners to come with them on that journey. It's one thing being entitled to carry out a major repair as a factor, but it's another thing then recovering your costs. So there's a lot of consultation going on with organisations where they're sitting down with owners saying, realistically, your building's going to need re-roofed in the next 10 years, what are we going to do about it? But the difficulty with trying to engage owners is that more often than not, they're either apathetic, they don't want to pay, or they can't pay. And again, through the right to buy process, a lot of people have purchased properties which have been heavily discounted. They've not really thought in terms of the future ownership of the property and the obligations that go with that. And I do think that that's a main difficulty for housing organisations, both associations and local authorities, when they're looking at properties and trying to provide factoring services.
Is there resolution to that in legislation? I agree with you, it's better if you don't take to the law, take it as a last resort, or it pushes you in the right direction without having to actually use it. But is there a way of resolving that? Because I think that's something one comes across with the housing associations, quite prepared to do it because they're paying for it.
Yeah.
But the private owners, you're quite right, they say, may have very modest means, and if you're not on the top floor, frankly, you don't care about the roof.
And the difficulty is that most housing associations, all housing associations, are now going to be bound by SHQS, the Scottish Housing Quality Standards. So that's a difficult one that they've got to measure out too. You've got tenants within a building, and if the property is substandard, they're not going to meet their SHQS. But if they don't engage owners that are going to agree with them to carry out major repairs, how then do they meet their SHQS? And it's a very difficult problem, and I have had some clients where they've withdrawn tenants within buildings where they've only got one tenant because they're not going to meet the cost of a £60,000 roof repair.
I see.
Where they have no prospect then of recovering from the other owners within the block. So they've removed a tenant and decanted them somewhere else because they have no way of being able to subsidise owners. Housing organisations are always bound by the fact that you can't use your tenants' money to subsidise owners, so you shouldn't be using tenants' money to throw at a major repair that you've got no chance of recovering the cost of.
Mr Dorn, you looked like you wanted to...
Yeah, I think Alison's correct. I think there's a distinct lack of understanding or education with the homeowner as to what they're buying into, what their obligations are. Also, the fact that as buildings age, they cost more to maintain. And there's a need more for education and understanding, and perhaps that's something that, rather than legislation, we need to look at that side of things, you know. And there's also the image of the factor, whether it private, whether it social, whether it a land maintenance company, is that everything that comes from them is more than likely a lie. You know, an example being we have a development of 329 houses where we manage the common ground on their behalf, and I recently met with an MSP who said he had received in excess of 100 letters concerned about the maintenance of it and the service. Now, 3 weeks prior to that, we had issued a letter to the owners asking to get them together with a tear-off slip at the bottom of it saying, we want to hear your views, we want to form a residents committee, we want to hear your views and take it forward as you wish, and we received 8 replies. You know, and that's simply because it came from us rather than going to an MSP who they trust. But that's more education and understanding.
That's a wonderful thing. We must have that. An MSP they trust. Don't name that person. The rest of us will be disenfranchised.
But I think that is the major problem here. And as you say, the whole I'm not on the top floor, I don't need to pay towards the roof. Right. You know, that's an education in other institutes as well. Citizens' advice, you know, we continually get letters from Citizens' Advice detailing income and expenditure, and on it is a satellite television package or a mobile phone package, yet the owner can't afford to pay for their buildings insurance. And that is seen as acceptable to citizens' advice, and that's really a big difficulty, because naturally the OFT survey said that 70% of people that responded to their thing were happy and thought that the services of a factor were reasonable and to a good standard, and they used the word a substantial minority were unhappy, and I think that's prevalent across the board. I think there is a problem with a substantial minority of people. And as a factor, whilst we need to try and take their concerns on board and alleviate them as best we can, we have to look at the overall client, i.e. the body of ownership, to see whether or not we're, because naturally, you could have a tenement of 8 people and you're never going to satisfy one person. But if you're satisfying 7, then you're doing a good job. And I think that's the real difficulty, it's that education of owners.
I've lived in a tenement, and trying to get some kind of security access, even though I was on ground floor, was a nightmare.
Well, yeah, one of the other...
Even though it didn't suit me,
yeah,
but I wanted
absolutely.
it for other reasons.
Yes.
But, if you're on the top floor, you don't care if somebody wanders in on the first floor and doesn't reach the top floor. It's a perennial.
One of the other submissions said that factoring is the management of common property or for several different owners. That's not what factoring was ever intended for. Factoring was intended to act for a landlord of a tenement, and you maintained the building on behalf of that landlord and you collected their rents. Now that's obviously diversified due to the change in ownership, and that's where factoring is now diversifying with the introduction of the Act, which will help.
Colin, you wanted an early bid to see the influence I have here.
Well, I think I just wanted to keep on your good side, convener.
At last.
The question actually is going off my script a little bit, but it's just a question that I'm reminded of.
You don't have scripts.
Well, I wrote it down just to remind
right.
myself. In my dotage, I suppose I need these things. It's really to do with a hypothetical that maybe someone can answer. And we have these developments that are set up, and it's more based on land management more than anything else. And you have obviously the house owners and the likes. Then you have strips of land which the factors will be brought in to deal with and the cost. Now, given the fact that people buy their houses, they pay their mortgages, all the rest of it, and this land is held by the developer, shall we say, for instance. Well, the question that was put to me some years ago is, why should people who are spending money on the mortgage, why should it be legal for somebody to keep a hold of a piece of land and force others to pay for their piece of land?
I feel like saying, as my history teacher used to say, discuss.
We're not directly involved in land maintenance companies, certainly. I suppose the argument would be that the people buying into that should be aware that that's there. And that's, again, another thing for solicitors or to be brought to the attention of a purchaser. Obviously, developers are now bound to provide information in factoring prior to the first sale. But what happens in the second and third and the fourth and the fifth sale? That's where it falls down, because that level of information isn't a requirement. If a solicitor doesn't ask the question, they won't get the answer.
Solicitors here. I'll get there before you.
I wasn't attacking solicitors, that's the minority.
Two of us rose out of our chairs in that quite
We're talking about the minority of people, remember. Absolutely.
But when solicitors are dealing with purchases and sales, certainly with purchases, they will make it plain they would have to, or they would be sued for negligence and compensation, what the obligations are that go with it. But many people don't want to hear that.
Absolutely.
They're too busy seeing their lovely flat IKEA'd out and so on. So I hope you're happy with Ms. Mirrors. I leapt in there for you.
I would also say though that through the Property Factors Act, they should have the written statement and get their welcome pack from their factor. And again, that's about educating owners.
Yes,
so they've heard it once through their solicitor, they should hear it again through their factor. But what we tend to find is that where people have been previously a tenant, they're not quite sure what factoring services it is that the RSL, the Registered Social Landlord, would provide. Then all of a sudden they become a property owner and they start getting bills through. They never realised that they were actually becoming, going from being a tenant to being an owner and all of the things that go with that.
I think that's an important point, but I'm afraid Mr. Keir's unhappy, and we mustn't have Mr. Keir unhappy, especially as he's in charge of the pandas, and it's very important that he keeps them on message this week or two. Would you like to repeat your question? You seem to be unhappy that it wasn't being answered.
My question actually was, given the fact that everyone's a landowner within the estate and you're responsible for your own property, why should we have a situation that the ground is factored out? It should be the responsibility of the owner.
I don't think that. Well, I'll let you answer it, but I think you've missed something there. Yeah.
I mean, certainly in here, in that it's not always the case that, as you heard from the two models earlier on, that some of the land does transfer into common ownership, and some of it remains in the ownership of an individual or a land developer. What you heard earlier on as well was that a lot of the time people had the right to use the common land, that we had a single ownership land model. That's not always the case in our situation. There is some private land that homeowners don't have the right to use, albeit that they continue to be asked to pay for a piece of ground that they actually don't own. And yes, they can go to the new homeowners housing panel in terms of the services, but there is an issue around cost. To answer your question, it doesn't seem right to us. It seems unjust to us that you would not be given the opportunity. I suppose the challenge in all of that you also heard earlier on is it's not as easy as owning just a bit of common land and cutting the grass. Often, lots of it does involve canals or sewage and play areas and indemnities and things like that, and that's where it becomes complex, and that's where sometimes individual homeowners do need the support of people that have that level of expertise, so that they don't end up in difficulties, because it's not just as straightforward as just cutting the grass or planting the plants or making sure it's well maintained. There's a lot of other responsibilities that go with some of it.
Yes, I have actually had a number in my constituency as an MSP and as a local councillor, indeed, which came my way over the years. But it's a fair question. The more I think about it, depending on which model, of course, is being used. I'm not saying it's the same everywhere. Yeah.
I think you'd have to change the law of contract and lots of other things fundamental.
It's what I was actually suggesting.
Yes. Yes, Roddy can comment about that. Graham.
Thanks, Convener. Much was said earlier about education and information, and it would be useful to hear from the panel who would provide this in the future. It's one thing to say there's a need for more from whom, who would be responsible for the provision of that information and maintaining the information up to date. And I go back to the point I made to the first panel. A great deal of friction seems to be caused by a lack of clarity in terms of the services that will be provided, the evidence that is value for money. There's mention of the £50 bulb transfer and so forth. All too often, that becomes a real issue in itself. Well, one would expect if it is a £50 exchange of a bulb, there would be an explanation of why it's £50, a breakdown, and about ongoing provision of information. So if you could indicate who do you think should be responsible for maintaining the guidelines for information and for education, and then responding to the second part of what I've just said.
I think it's coming together and working. I don't think there's any one party. I think it's something that has to be, led by the government, because at the moment in time, the level of trust in the factors isn't there. And to get that level of trust back isn't only about the services offered, it's about hearing it from other angles. And I don't think any other factor would be unhappy at coming and sitting in on government boards or seminars to try and help educate the homeowner. So I think it's something that has to be pulled together by the government, but ultimately led, by those carrying out the maintenance and the services and getting the experiences from them. Because as you say, there is a lot of friction. There's a lot of unhappy people. When I say a lot of unhappy, it's still in the substantial minority, but there are people who are unhappy, and many are simply unhappy because they don't understand, as you say, the cost of replacing a light bulb, that if they don't do it themselves, that they have to pay for a qualified person to do it, who then attracts a suitable rate to do that. And that's the simple answer. So really, it would be, I think, in our opinion, kind of a government-based thing, you know, because we've had all the Tenement Scotland Act, the Property Factors Act, which is all about enforcement of the property factors in the legislation.
Yeah.
What we really need is something with the owners on board as well, so that the owners that aren't paying or refuse to pay start to understand the effects that will have on them long term. You know, and again, I went to a recent seminar in Paisley run by Renfrewshire Council, who provided frightening statistics as to the level of number of houses in disrepair and the number of tenants in disrepair. You know, yet there's nothing to do because there's no public funding, which rightfully there's no public funding because the private owner should be paying for it. But there is definitely a problem which, if it isn't treated, is going to lead to the housing stock, you know, getting into a state of, you know, dilapidation, which is a factor naturally, and as a for-profit organisation, we obviously want to continue maintaining, because obviously if we spend more money on a building, we don't earn more money. You know, that's the simple facts of it. You know, so it's not beneficial to us to spend a lot of owners' money because we don't make any more money out of it.
Going back to the point that you made there about government-led and sort of ongoing, and maybe I should know this, but I don't. Is there a forum in existence in Scotland where the government is represented, which enables current experience and knowledge to be developed in order that guidance can be offered across Scotland in that regard?
No, I don't. I think there's been many working parties, but I don't think there's an actual forum. That you've had things like the Glasgow Factoring Commission, all these kind of bodies, but there's nothing pulling everyone together. And I think
Should there be?
Yes, absolutely.
Thank you.
There's also the issue about how you would keep tenants or property owners within something that's been property, how you would keep them informed without it just a bill coming through the door, or, by the way, we've had a look at the roof, it's £30,000, your share is £5,000, and that's the first to hear. Is there any kind of ongoing, you know, because we have a turnover in tenements maybe that you don't have in other places, the kind of tenancy, is there any way you keep people informed so they know what their rights are, and maybe remember to save something or whatever towards any repairs that may have to be done communally? Do you do that?
I mean, certainly I'm part of the Glasgow Factoring Commission, and this is one of the questions that's came up. And when we've looked at it as a commission, obviously the report is still to be finalised and distributed. But believe it or not, there's actually a tremendous amount of documentation that's actually out there and produced by a number of different bodies. From the minute people actually buy their house, there's the right to buy legislations, consumer focused themselves, produced common systems, common repairs, common sense. Local authorities also produce leaflets. As a large-scale factoring organisation, we produce a wealth of material available through self-service online, through to homeowners' handbooks, and the Homeowners Housing Panel, the Factoring Act, actually stipulates that there should be written statements, so every factoring organisation should be providing written statements and needs to re-register every 3 years. For me personally, there is an issue around about making it easy for people to understand it all together. Legislations, there's a number of legislative acts and documentation again that's not easy in terms of laymen to actually to understand and to decipher themselves. One of the experiences that we had, though, is that people believe that homeowners won't switch factor, the low levels is because they're not well informed. In our written evidence to you, we went through the housing stock transfer. So from 2009 to 2011, we had over 5,000 homeowners that were in mixed ownership blocks that had to make some choices and make some decisions about who they wanted to be their factor. We spent quite a significant amount of money, ourselves and the receiving landlord, on documentation, giving them a benchmark of what each of the service provisions were like. We door knocked them, so did the incumbent. We provided them options for self-factoring. We provided them the options of going to commercial factors. And what I've got to say to you about that, it wasn't a lack of information that actually prevented them from actually changing to self-factoring. No one chose that option. it was actually that wasn't important to them. You know, the 43% of them actually decided not to do anything, despite the efforts and the knowledge and the materials and things like that that were there. And where they did make a decision to change factor, they actually chose another registered social landlord, who, and they could say that they don't see any difference between the two of them. But there is an awful lot of material out there. Is it all in the one place? I think the answer is no. But is there lots of it? I think you would find that there actually is.
Yeah. I mean, I think that that's commonly accepted in many fields, that there's a lot of information out there. You know, even accessing the internet, you're swamped. It's pulling it together in a manageable fashion that people can cope with when they come home of an evening after a day's work, or when they're dealing with other crises.
Yes.
It's to be able to manage this wealth of information to suit their purposes. And it's still, no matter how much information's out there, I know from speaking to people who have experience of using your facilities, they don't understand why they're being asked to pay for painting, for instance, and they don't know where the painting was, or repairs, and they've no idea exactly where these repairs were occasioned. So some very basic things, no matter, you can have a ton of papers. If at the end of the day there isn't a sheaf of paper that says, we're talking about the landing adjacent to your property, that's the essential piece of information they need to say, well, I don't want to spend £50, but I see the paint, it is much better, I need to pay the dues.
I mean, certainly, I agree with you. We've created a common repair team recently where our factoring officers are actually going out and having those conversations and getting consents on doorsteps rather than through letters. But I've got to say to you, that brings a cost to it.
Yes.
And we're piloting that just now.
Yes.
And what you've got to balance is how much are people able and willing to pay for a service against that level of communication that we're doing. So we are running a pilot that just now, but actually that's resource intensive as well, you know, over and above letters.
Yeah.
And one thing that I would add, we acted for the receiving LHOs when GHA transferred. So we've got the, you know, a kind of feeling of the meetings from the other side. In the majority of cases where the factoring didn't transfer, it was simply because the meetings weren't coded, because we couldn't get enough people to the meetings. So it's trying to engage people, and I think we did look at doing things like proxy voting and try to be a wee bit kind of inventive in terms of how we got the votes, but even then it was very difficult to engage.
Online voting?
Well, I think the difficulty was that if you do...
You tried it, did you?
Believe it or not, probably our customer base, we are encouraging our customers to go online, and but the majority of them at this point in time, it's different whether it's in the private sector and whether or not it's the social sector, how many customers are actually online. So we did offer that, but we didn't have an awful lot of customers that actually had those facilities to do that. But we did do public meetings, and you know, there was a whole variety of communication methods tried.
I think the difficulty for...
That was a good suggestion, I heard that. Why didn't you suggest that? Ask that one.
I was waiting for the space, convener.
You've got it now, I've given you it.
When women are having a debate, I've learned to stay out the way.
Oh, your
Tweeting
wife's
on
achieved
phone.
something. Go for it.
Do you go for use of mobile phones, texting, tweeting in order to get a feedback?
Believe it or not, Glasgow Housing Association...
Believe you every time.
We do have Twitter, and we do have... our customers can actually use their phone, their app, to report our pay and things like that online. So we are actually using those self-service options.
In terms of some of the options?
Not in voting, because
why not?
We don't have that level of data.
And say you've got difficulty there in terms of how do you know that that person is the person who say they are, in terms of tweeting, and is that an appropriate proxy vote if that's what you're asking them to do to attend
It's useful
a
to have that in the record. Thank you.
I would say that from our experience, a property was transferred from us through an online voting mechanism. You know, so it can work. But what I was going to say was the difficulties you've got is the differences in homeowners within each block. You could have 2 blocks of 300 flats getting exactly the same service for exactly the same costs, but they'll have different opinions of you. Or you'll be able to get a committee together, co-rate and working in that one, but you won't in that one. So that's the difficulties that a factor faces from that side. It's not as cut and dry as doing the same thing to the same building or a different building and getting the same result.
But I don't seek to go too far with this thing because I don't think we can get to the bottom of it. But your perception of having serviced both these flats in a similar fashion might not be the way it's been received at the other end.
Absolutely.
So I wouldn't say it's illogical that you would have more complaints in one area than another. Might be how they feel they've received the service.
Yes, yeah.
Sandra?
Yeah,
Because this is this seems to me more of west of Scotland. I mean,
Well, I think I know the GHA, I know the LHOs and obviously the private factors as well. But this is something entirely different. I could go on about different factors and how private factors have floats and RSLs don't and things like that, but I don't want to get into that. The one thing I do want to ask, and it came up a lot in the previous panel, was Section 53. And I just wanted to ask how that affects yourself. I know for the submission, particularly, regarding solicitors and that type of thing, how it's made it much more difficult, because I think that's one section we really need to look at for post-ledge. So I just wondered what the panel, their opinion on Section 53 is.
I think from my perspective, Section 53 itself is fairly difficult to understand, but to try and describe it to a client and for them to understand it is really difficult in terms of what is a common scheme, are the properties related, and it's this related properties element that people kind of fall down on. There is a wee bit of guidance in relation to what related properties are, but it's not particularly robust. And whilst I don't agree with someone previously saying, no, I think we should just scrap the whole thing. I think perhaps more robust guidance in relation to what are related properties, what is a common scheme. Does it have to be identical provisions, or is it similar provisions that would enable somebody to be part of a common scheme? I've got a particular difficulty with this with the majority of my West Coast clients who are successors to Scottish Homes. They got a Scottish Home stock transfer where essentially they got large areas of ground, and the properties who had been purchased through right to buy were subject to a deed of conditions. The deed of conditions was very straightforward. It says everyone within the development bears an equal share of the cost of maintaining the common parts of the development, and then gives a very generic. So that seems fairly straightforward, but there is no definition of what the development is. So when you then try to enforce those provisions, there's nothing. Who do you enforce them against? Who is the community? So then you have to really look to the Title Conditions Act to try and import in, are the properties part of a common scheme? Are they related? The difficulty with the Scottish Homes deeds of conditions is they didn't provide for the owners to have a common share in these open spaces. In fact, they didn't provide even for the owners to have use and enjoyment of them by virtue of where the properties are. They do have use and enjoyment of these areas, but there's nothing specific in the provisions of the deed. And that, for my clients, is a really big difficulty. They are routinely going out, carrying out open space maintenance and recharging it because that's all that they can do. Especially, some of my clients are maintaining estates where there's 3,000 properties in it. If they were to stop doing that, one of my clients who makes no money out of factoring routinely invoices about £400,000 a year. If they stopped doing that, the communities would fall into complete disrepair. But what is their option? Because if they are found that this provision in the Title Conditions Act does not provide for that condition within the titles to be enforceable, then do they just stop doing it? If they stop doing it, you've got communities that fall into disrepair. If they carry on doing it and it's found that they shouldn't be doing it because they can't recharge, where does that leave them? They're £400,000 adrift. So that's a really difficult balance. So you did mention earlier on that really Section 53 was brought in for mixed tenure developments, or that may have been the reason. But that's okay where the titles prevail. But if the titles prevail, then we don't need to look to the Title Conditions Act. And in the main, I'm looking to the Title Conditions Act for my Scottish Homes deeds of conditions, where there are no plans, and it's difficult to then bring in the related properties and scheme properties element of it.
So we need to amend.
I think so.
Well,
especially in that circumstance.
if you've any ideas about how it should be amended, it'd be delightful to have them, because we're academics come to us. I'm not expecting you to be a legislative drafter, but to give an idea of how that makes it easier, because the law's no good if it's not practical. I don't want to spin things out too long. Roddy, is that a signal you're wanting to ask a question?
It was a very...
It's a sort of flick of the finger. I have to learn to understand body language in here beyond my abilities. And Colin, you've got a supplementary.
Yeah, it was actually on the back of Sandra and the
OK, I'll take that, then I'll take the flick of the finger, right.
On the tenemental properties, because obviously they are owned by different people. One of the problems actually we had in Edinburgh, or have in Edinburgh, is Edinburgh's got most of the legal HMOs in anywhere in Scotland. And it's a case of, there are instances of blocks of 8 properties and something like 6 or 7 of them are run by factors. Is there something in here that, well, they were incredibly difficult to all, join up the dots, so to speak, if there was any problems in the relicensing. I should say that was I was chair of the local licensing committee as regards HMOs here up until 2011. And in terms of the title, there never appeared to be anything that made the factors work together without, just in general terms. Some of them wouldn't talk to each other. Some were not only factors, but they were actual owners as well. It was all over the place. Is there something we can do in this legislation to help that situation along a bit, and how people get common repairs done?
With the legislation, I suppose, binds the homeowner rather than the factor. It doesn't bind the factor. All the legislation is related to the homeowners rather than the factor. But again, it's more of getting the factors together or the homeowners together to get their factors to talk to each other. Obviously Edinburgh is slightly different in that it was for many years more self-factoring and it isn't as big as the West Coast. But certainly that is changing. Whether that's a sign of the economic downturn or a change in views. But certainly there's more and more properties becoming factored in Edinburgh. But beforehand it was certainly self-factoring. But I don't think there's any legislation as such. Your Property Factors Act will help homeowners whose factors don't talk to other factors, but I don't think there's anything, a working party or a group that's pulling together in education may assist in that, but I don't think there's anything for legislation.
I mean, certainly in terms of letting agents, if you like, acting on behalf of owners and factoring blocks. In practice, as a factor, it's flagged to us that there's difficulties in a block because of houses in multiple occupancy or anything else for that matter, and we know that there is letting going on. Certainly the register that's there for, letting agents have got to register for actually helps us identify who we need to be speaking to actually join up a little bit. But I totally agree with David. Certainly all the legislation's more focused on the owner and the owner's responsibilities to repair properties, as much on the factor when they're instructed to actually act out those instructions and make sure that they're completed.
I think the Property Factors Register has also assisted in that, because now, to us it's easier to liaise with another factor than it is to liaise with a block where there's self-factoring. So the Property Factors Register allows us to do that now, whereas before you could send a letter to 8 homeowners and get no response and never find out who the factor is. Now we can see if there's a factor, and that will help things.
And that only came into force when last year? October last year, so it's just been running, Colin, and that would help identify. I want to take this last question because we've still got something else to do.
It's a very general question, really. Just you talked about the 2011 Act improving things for homeowners in terms of looking at the services that are being provided by the factor, but obviously it doesn't contain anything in terms of valuing the services. Any just general quick thoughts on kind of how we might look at that aspect?
I think the homeowners themselves will be able to value the services offered to them, because they'll have the transparency of what they're getting by the terms of service for the factor, and they'll be able to go out and do marketing exercises based on the different terms of service offered by other factors, which in itself will give them a cost equivalent. Now, really, when you look down to it, the only cost that should be an issue is either your insurance and the management fee. because the services should be able to be transferred over, be it a cleaner, be it a ground maintenance or a roofer. They're all transferable, so it doesn't matter who factors the building, that contractor can be used. You know, so really the only cost you're looking at is the ability to obtain insurance and the management fee, which can be regulated quite easily by the homeowners.
I'm going to thank you very much for your evidence and bring it to a close, and thank you for the time you just said. But I hope you found it useful. I can say to members, we're now moving on to the next item on the agenda. Thank you very much. And we're moving into private session. So I'll just wait for the room to clear.